barassays.com prepares like an overview of Crim Pro, starting with the Fourth Amendment arrest, subpoints probable cause to believe crime was committed, and needs a warrant for detentions, including station house, auto exceptions, blocks, like blockades. Search and seizure is the second part of the Fourth Amendment, consisting of, got a couple arrows over to reasonable expectation of privacy violated by the government, state action. Kind of applies to what I just spoke of, but even more so search and seizure. Requires government conduct, which is the state action. Reasonable expectation of privacy, I just spelled out. And not... What does this say? Location of car, voice, curtilage, trash, open fields, and handwriting. So you have a reasonable expectation to that type of thing. However, details, misleading, independent, neutrality of magistrate. And so right now I'm talking about the third caveat, which is the valid search warrant. Independent neutrality of magistrate, proper execution, prompt, clear, and specific as to where to search and what to seize. Exceptions to the warrant include search incident to lawful arrest, automobile, plain view, consent, stop and frisk with a reasonable suspicion of a criminal act, and exigent circumstances such as evanescence of evidence. Persons or places searched, including border, luggage, glove box. I have here wiretapping in public school students as slightly different than your run-of-the-mill persons and places to be searched. I suppose it goes under that. The exclusionary rule, and I've got this quoted as illegal evidence admitted can be overturned in appeal. Crawford versus California, if a harmless reversible error. I guess if not a harmless error. Harmless and reversible error, or reversible error. I wonder if you meant to say irreversible. Limitations on exclusion, grand jury, no attorney, civil, immigration, parole, illegal evidence, waiver given, specific immunity, good faith defense to exclusion, judicial opinion later changed, statute later unconstitutional, defective search warrant, exception to good faith defense, one, underlying affiant, lacking probable cause, maybe, defective on its face, police officer lied or misled magistrate wholly abandoned, fruit of the poisonous tree, tainted and illegal, evidence obtained obtain a legal process to obtain evidence. Prosecution defenses is an independent source, inevitable discovery, and defendant's free will intervenes with the, I suppose, the fruit of the poisonous tree or the exclusionary rule, one or the other. That's so painful to read because it's so small. Fifth Amendment is the privilege against self-incrimination, not physical, testimonial with illegality, compelled at trial. I don't know what this says. Scope. Okay. Talking about the scope. Ways to eliminate the privilege against self-incrimination is granting immunity at trial can't comment on silence at trial. The state can't do that. But the grand jury can grant immunity to the earlier point. The second point under the Fifth Amendment is the Miranda. First, you test for custody. It's the other page. On the other page, what have I got for custody? There's another page. That's okay. So post-arrest interrogation, waiver of the right to remain silent, right to counsel. Fifth Amendment also protects against double jeopardy, which exceptions permitting retrial. Same offense or lesser included doesn't apply to separate sovereigns, which means that the federal and the state sovereigns can both find a defendant criminally liable for the same offense. A Sixth Amendment right to counsel says no rights, waiver, effective assistance to counsel, deficient performance by counsel, but for a result would have been different. So I've got a couple of things written in the margin, even though there's not much of a margin here. So the critical stages when a counsel should be available. I've crossed out lineups, but pre-trial, post-trial, and I suppose it's in trial. Just to name a few. Pre-charge led to conviction. Right to speedy trial is also protected under the Sixth Amendment. Look for prejudicial to the defendant and the totality of the circumstances. Remedy, dismissal with prejudice. Right to jury trial. This appears to be from the Sixth Amendment. For serious offenses such as the death penalty or 6 to 12 jurors and the guilty pleas. It's guilty NG, not guilty. Right to confront witnesses. Exception is when the defendant is disruptive. Eighth Amendment death penalty, also cruel and unusual punishment. For the death penalty, it's not placed on minors or the mentally challenged, or grossly disproportionate to the crime committed. I also might add, if it's a co-party and the act was undertaken by their co-party and not themselves, in a conspiracy, for instance. I have here the Fourth 14th Amendment, burden of proof requirement is beyond a reasonable doubt. It prevents also against unnecessarily suggestive identification process and also confessions. Criminal law basics. Oh, I didn't know I was going into criminal law. Oh, geez. Okay, there's criminal law as well. So, actus reus and omissions, mens rea, including specific intent, malice, general intent, strict liability, which is not mistake or accident is kind of irrelevant. Voluntary, I don't know what that stands for. VI, defense, I don't know. Concurrence between the actus and the reus and the mens rea. Causation, cause and fact, and proximate cause. Accomplice liability rule, aid, encourage, counsel, principle, with the intent to encourage the crime is a specific intent. If I remember correctly, does it merge? I believe it does, and I believe that. But I'm going to confirm behind me. I know it's here. Merger applies to solicitation and attempt. Doesn't say anything about. I thought those accomplices stupid. Okay. So withdrawal. So there's liability. I have continuous here, and defenses will withdraw, protected class, accessory after the fact, and incompleted. Inchoate offenses, specific intent required for solicitation, attempt, and conspiracy. In solicitation, only charged to the solicitor asking someone to commit a felony with intent to the solicited person commit the crime. Refusal is no defense as it pertains to the solicitor. Attempt, specific intent to commit the crime, and this is attempt, sorry. Substantial step in the direction. Mere preparation is insufficient. It says, I also found a new test. I think it's called the proximity test. I thought that was neat. So use that as well as the substantial step test for attempt. Defenses are factual impossibility. That's not a defense. Legal impossibility is a defense. I think that's how that reads. And abandonment is not a defense. Conspiracy is an agreement between two or more people with a specific intent to enter into the agreement and specific intent to by at least two to achieve the objective of the agreement. I have here fourth overt act in furtherance of that agreement. I also have here there's no merger, correct? Whereas there's a merger for solicitation and attempt. And in liability, I have one for all for one. Defenses, impossibility, no. Withdrawal, no, with exception. Obviously, since withdrawal is a defense. If it's an effective withdrawal. Homicide, murder, reckless indifference, malice, forethought, felony murder, defense to felony, defense to murder. A point of safety is the end of the commission of the crime ends. Limitations, that would be one of them. When you've reached a place of safety, then what you do from there on out is new crime. Not necessarily felony murder if you murder someone after that point. Red line, not for death of co-felon. I guess that's what that means. I didn't know what that meant. Degrees, murder is second degree unless deliberate and premeditated or felony murder. Deliberate and premeditated. So deliberate is the cool and dispassionate decision. And then the premeditated is that it occurred well enough before the act is formed, preformed. Voluntary manslaughter, adequate provocation will reduce murder to manslaughter. Sudden intense passion is what provocation is, and it's in the mind of an ordinary person where an ordinary person could not cool off. This person did not cool off, and involuntary manslaughter, criminal gross negligence, or commission of unlawful act. For involuntary manslaughter, and I wrote here temporal safety. Again, that's like, I guess, the same idea as to when you're committing a crime and someone dies. When is it no longer a crime? I wrote temporal safety. So crimes against the person, assault, battery, rape, kidnapping, crimes against property, larceny, embezzlement, false pretenses, receiving stolen property, robbery and extortion, burglary, arson. Defenses, self-defense, defense of others, defense of property, insanity, intoxication, and mistaken infancy, crime prevention, necessity, other. So these are the last two sections before we can even get to the next section. So for crimes against the person, assault is an attempted battery, serious injury, death, must intend to commit battery. Assault as a threat is great injury. I think, general intent. So SI doesn't stand for serious injury. It stands for specific intent. Defendant must intend to commit a battery. For assault as a threat, it's a general intent crime. Intentional creation, other than by words of a reasonable apprehension in the mind of the victim of imminent bodily harm, if actual touching, then it is a battery. Battery is general intent, completed assault. It includes unlawful application of force to the person of another resulting in bodily injury or offensive touching. Rape is the unlawful carnal knowledge of a woman by a man, not her husband, without her consent. Kidnapping is moving or secreting a person. It involves unlawful confinement of a person that involves some form of movement or of victim or concealment in a secret place. False imprisonment, unlawful confinement of the person without their valid consent. Crimes against property, larceny, the taking, carrying away of tangible personal property of another by trespass without consent or with consent by fraud with the intent to permanently deprive. Embezzlement is fraudulent conversion of personal property of another by a person in lawful possession with intent to defraud. False pretenses, obtaining title to personal property of another by an intentional false statement of past or existing fact with the intent to defraud. Larceny by trick is that the victim is tricked into giving up mere possession by misrepresentation of fact to give up mere possession. Receiving stolen property is not convey title, receiving possession and control of stolen personal property known to have been obtained by crime of another with the intent to permanently deprive owner of his interest in the personal property. If not stolen when received, then attempt. Robbery is larceny plus assault. The taking of personal property of another from another's person or presence by force or threat of imminent death, physical harm to victim with intent to permanently deprive. Victim must give up property because they feel threatened. Extortion or blackmail, obtaining property by threats of future harm. There's other definitions. There's like 4 different definitions for that. MPC, that's the Model Penal Code, can reduce a common law element. Burglary, breaking and entering of the dwelling of another at nighttime with intent to commit a felony inside. Arson, this is malice crime. The malicious, intentional, or reckless disregard of an obvious risk. Burning a dwelling of another. House burning is burning your own house down. Defense is self-defense, victim reasonably believed necessary to protect themselves from imminent use of force by her. Deadly force without fault, confronted with unlawful force and threatened death or great bodily injury. So the majority doesn't require that you retreat. The minority, you must retreat unless the attack is in the home. The police officer making lawful arrest of the victim is being raped or robbed. Doesn't say anything about when it's safe to do so. If it's safe to do so, it happens to be an element of retreat. Aggressor generally can't accept, effectively withdraw until victim or victim escalates into a deadly fight. Right, so they can't use deadly force, that is. Defense of others may use force in defense of another if you reasonably believe the person assisted has the legal right to use the force in their own defense. You can use so much force as you would think they're justified in using their own defense. I have here defense of property, what's reasonably necessary, never deadly force in defense of property unless it's self-defense or defense of others. Insanity, McNaughton test is you didn't know right from wrong, know your act would be wrong, or understand the nature and quality of his actions, irresistible impulse, unable to control his actions or conform conduct to the law, Model Penal Code, couldn't appreciate criminality of his conduct or conform his conduct to the requirements of law, endure him as crime wouldn't have been committed but for this disease. Intoxication, if it's voluntary, it's pretty clear. If it's involuntary, there's insanity treatment, where this doesn't seem to want to be often used. Take without knowledge of its nature, under direct duress from other, or doctor advice while unaware of the effect. So I just got a MBE question about this. Medicine the doctor gave the patient without telling them the potential side effects, and they, under the influence of the medication, they thought their neighbor was creating rumors or spreading rumors about them. They got really paranoid and they just took a knife, went to the neighbor's house, stabbed them and killed them. And they answered the door. And there was no defense for that. And I think the rationale here was like, there's like 2 separate rationales. I think like 1, he probably knew his act was wrong, and 2, he probably understood the nature and the quality of his actions. So it was like, really? I mean, whatever. It seemed to me like involuntary intoxication, if ever that would ever have applied, but no. So for voluntary, altogether, I think it negates it negates specific intent crime, but not general intent crime. can form the general intent to go stab your neighbor. Even though murder needs specific intent. Mistake, reasonable. I have here, I guess that applies to general intent, specific intent, malice, crimes, unreasonable, specific intent, but mistake never reduces strict liability crime. Infancy, there's no liability if a person's under the age 7 to 14. There's a rebutable presumption. Didn't understand wrongfulness of the act. And crime prevention, non-deadly force may be used as reasonably appears necessary to prevent a felony, serious breach of the peace, necessity, objective test, reasonable belief commission of crime was necessary to avoid imminent or greater injury to society, other, duress, consent, and something else. Entrapment, not predisposed to the crime before set by law enforcement, set up by law enforcement. So I thought I was going to go through also like how to write essays on these things. But, 26 minutes in. Let's just see what we can do. Embezzlement is fraudulent conversion of another's property by a person in lawful possession of the property. Larceny is the trespasser taking, carrying away of another's personal property with specific intent to permanently deprive that person of the property. Trespassery means property is taken without the owner's consent. Taking is a trespassery property removal from the owner's possession into another's control satisfies taking. Carrying away, also asportation. Conversion. Conversion is a serious interference with the property owner's rights to the property. Usually the owner needs to demand return of the item. I'm reading the footnotes right now. What's 2 here? 3, break down elements into headings. Trespassery, that is. Okay, that's an example of breaking down larceny into its several elements. Custody versus possession. What is that pertaining to? Oh, yeah. This is just breaking down larceny into its elements. Let's go on. That was page 1. Page 2, slight property movement satisfies carrying away. That's just to break down the element. Another's personal property, personal possession of someone other than the defendant, specific intent to permanently deprive at the time of the taking, specific intent to permanently deprive the property owner must be present. We've got a murder doctrine citation here. Traditionally, under the murder doctrine, if a person's conduct constitutes a felony and a misdemeanor merges into the felony, and the person cannot be convicted of the felony but not the misdemeanor. There is no merger if the crimes are the same degree. All felonies are all misdemeanors. So, just talking about if the essay question was asking about larceny or robbery or battery assault, and suggesting that you do, I think, the lesser crime before the heavier crime, because you can refer back to the, initial elements that you set forth. Modern, the merger doctrine does not apply, 1, unless a jurisdiction characterizes the double jeopardy clause prohibition against multiple punishments for the same offense as a merger of the lesser included offense into a more significant crime, and 2, for solicitation and attempt. I'm just going to read that. A defendant may be tried but not punished for solicitation and the completed crime. For the attempt and the completed crime, solicitation and attempt merge into a completed crime. That's the explanation there. I understand that part. What was that first part all about? I was like talking about murder doctrine. Unless it doesn't apply unless the jurisdiction characterizes the double jeopardy clause prohibition against multiple punishments for the same offense as a merger of the lesser included offense into the more significant crime. Robbery is larceny by force of intimidation, where the property taking is from the victim's person or presence. Right. Cannot be convicted of larceny and robbery because of the merger doctrine, but the elements of one crime are inside the elements of the other, and I just went through larceny. Extortion is the taking of another's property by threat. And I've got a different from robbery. Property need not be on the victim or in presence. Threat of harm need not be immediate or physical. What is this? 8. Intimidation. Victim gives property because of immediate threat of physical injury to victim, family member, or other person present. Threat to damage or destroy property other than the victim's home insufficient. A victim gives property for another reason, such as wanting defendant to go away. If you're selling for a defendant, attempted robbery, not robbery. Assault is an attempt battery or an intent to create reasonable apprehension of imminent bodily harm. So what's a battery? Minority limits assault to attempted battery. Majority allows both. If the interrogatory asks, I don't know why we're talking about murder right now, but if it asks for murder and lesser included offenses, discuss common law, first degree, second degree murder, voluntary, involuntary manslaughter. If the interrogatory asks for the crimes discussed, assault, battery, murder, common law, first degree, second degree murder, voluntary, involuntary manslaughter. Okay. Those are just the footnotes that go along with what I was just saying about assault and battery, which is unlawful application of force to another person that causes bodily harm or constitutes offensive touching. Now, there's some more footnotes for application of force. That's contact with the victim is mens rea. Offensive touching is the actus reus. Attempted battery, it says, for battery, defendant touches the victim or something attached to the person. Assault occurs with no touching. Attempt requires specific intent to commit a criminal act coupled with a substantial step taken towards the commission of the intent crime which fails to be completed. Again, I was doing the proximity test in criminal law. I'll keep applying it if it came up. Here, thus, aggravated assault by statute, assault with a deadly weapon or intent to rape or maim may carry a greater penalty. And then it gives battery again. Aggravated battery is by statute, battery may carry a greater penalty when serious bodily injury, use of deadly weapon, or victim is a child, woman, or police officer. Murder doctrine. Traditionally, under the murder doctrine, if a person's acts constitute a felony and a misdemeanor, the misdemeanor merges into the felony, and the person can be convicted of the felony but not the misdemeanor. There is no merger if the crimes are of the same degree. All felonies are all misdemeanors. So, assault and battery merge into murder? Okay, they merge into murder. If you kill someone. If there's a homicide. How many more pages? They're a little out of order, maybe. Goodness gracious. So, modern murder doctrine. I'm not going to go into this again and again and again. So this tends to be a little duplicative. Common law murder. At common law, murder was defined as the unlawful action killing that causes the death of another living human being with malice aforethought. So you then break down unlawful action, did not have a legal excuse for defendant's actions such as insanity, intoxication, or immaturity. Defendant's killing of another human being victim was not unlawful. Was or was not unlawful. So, causation. To prove a homicide, the prosecution shows the defendant's act was the actual and proximate cause of the victim's death. Actual, if but for the defendant's acts, the victim would not have died. The defendant is the actual cause and fact of the death. But there are multiple causes of death. The defendant is the actual cause when the defendant's acts are a substantial factor in causing the death. So there's going to be several footnotes to read in this section because they're introducing now common law murder. Unlawful means without legal excuse. Action is action reus. It can be voluntary or involuntary act. A victim needs to be living. Be aware of fact patterns where the person being killed is already dead. Malice is the mens rea. If the only state of mind tested is felony murder, tailor the rules and skip actual cause. Traditionally, felony murder required both actual and proximate cause. Modernly only proximate cause. The truth for actual cause to prove a homicide is similar to actual cause and negligence, except instead of plaintiff, use victim. Instead of injury, use death. Substantial factor means defendant sets in motion forces that lead to victim's death. I'm like kind of exercising at the same time. I'm tired. All right, what else? Proximate cause exists when the victim's death is foreseeable result of the defendant's acts, when multiple forces contribute to the death. What do you do? An unforeseeable intervening event severs the causal connection between the defendant's acts and the victim's death. Here, thus, there was or was not causation. Here's malice aforethought. Malice aforethought requires 1. Intent to kill, intent to inflict serious bodily injury, depraved heart, or felony murder. Intent to kill. Action accompanied by the intent to kill, which is the legal cause of the human being's death, constitutes intent to kill murder. Intent to inflict serious bodily injury. A person who intends serious bodily injury but actually succeeds in killing is guilty of murder despite the lack of intent to kill. Oh my gosh, they have this as, they don't have it as bark, they have it as crab. So bark is your felony murder crimes, burglary, arson, rape, robbery, and kidnapping. Depraved heart means reckless indifference to an unjustifiably high risk to human life. Extreme indifference to human life is depraved heart murder. Reckless action that manifests in extreme indifference to human life. Felony murder. To convict defendant of felony murder, the prosecution establishes 1. The defendant is guilty of inherently dangerous felony. The felony is distinct from the killing. The death is a foreseeable result, proximate cause of the felony, and killing occurs during the commission or attempted commission of the felony. Defendant guilty of inherently dangerous felony. Rape is, traditionally rape is unlawful sexual intercourse with a female who is not a wife without consent by force of threat of immediate force. Modernly, a rape victim can be male, no force is required, and the husband can rape a wife. Used to be a carnal knowledge, the slightest of penetration. What do the footnotes say? Give the elements of the felony. Under felony is the lesser included offense of murder. The facts give more than one felony. Use a separate heading for each crime and prove the facts. The elements for each crime. This is an example for rape. Analyze if the elements of the felony. Okay, so I'm just going to skip all this. Killing during commission of attempted commission of a felony. That's great, but let's move to first-degree murder. First-degree murder, created by statute, is murder committed during the perpetration of an inherently dangerous felony under premeditation or deliberation or using egregious means. Here, a statute was inferred from the defendant being arrested and charged with murder during perpetration of inherently dangerous felony. Those include ARC, we talked about. Rape is here as one of those dangerous felonies. Just checking this. Footnotes on this. Okay, so on the next page. Under premeditation deliberation, premeditation means the defendant plans a killing. Deliberation means the defendant reflects on the idea of killing after forming the intent to kill long enough, even if briefly, to be fully conscious of the intent and have considered the killing. Yeah, this whole egregious word I've not seen. What's the footnote say? Ambush, lying in wait, torture, bombing, terrorism, and poisoning. Cool. I didn't know they went under the term egregious. That's egregious. I didn't know where lying in wait sort of was hiding. It's in the egregious term that we've not used to date, or at least in a long time. Second degree murder is common law murder or all murder not in the first degree. Now you got offenses being listed here. So I guess we're through it. We are getting through it. I am not reading any of these. Just because I don't feel like it. Here's involuntary manslaughter. Not saying that they're not important. They're being important. I must have I thought I had like a chart or something for them all. I do. Just not on the wall. So, got one for criminal capacity. Manslaughter. Involuntary manslaughter is the unintentional homicide committed with criminal negligence or during an unlawful act. Criminal negligence is a reckless action or inaction when there is a duty to act that puts another person at significant risk of injury or death. An unlawful act is a killing committed during the commission of a misdemeanor or felony not enumerated under the felony murder rule. Do not mix up criminal negligence with depraved heart murder. Criminal negligence is unintentional killing without malice aforethought. Oh well. Exclusionary rule. Under the exclusionary rule, evidence obtained in violation of the Fourth Amendment may not be introduced at trial to prove guilt. Thus, fruit of the poisonous tree. Unconstitutional search and seizure. Under the fruit of the poisonous tree doctrine, the exclusionary rule extends to secondary evidence obtained as a result of unconstitutional search and seizure, unless an exception to the fruit of the poisonous tree doctrine applied. Let's see, what does the footnote say? Secondary evidence obtained as a result of excluded evidence. Poisonous tree means evidence excluded because there is a constitutional violation. All unlawfully obtained evidence inadmissible unless the fruit of poisonous tree doctrine exception applied. Primary taint means police misconduct. going into criminal procedure. Independent source. Secondary evidence may be admissible if the evidence is discovered in part by an independent source unrelated to tainted evidence. All right, so we're going into criminal procedure because Fifth Amendment Miranda is written here. The Fifth Amendment, applicable to states to the 14th Amendment, provides that no person shall be compelled in a criminal case to be a witness against him or herself. The statement obtained as a result of custodial interrogation may not be used against a suspect at trial unless the police inform the suspect of Miranda rights and the suspect intelligently waives those rights. Custody exists where a person is not free to leave or significantly deprived of freedom of action. Interrogation. Interrogation is questioning, expressly or through words of actions initiated by law enforcement that the police know or should know are likely to elicit an incriminating response. So, just looking at the footnotes, tells you what the Miranda says: the right to remain silent, anything you say can be used against in court, right to presence of attorney. If you cannot afford attorney, one will be provided. Traffic stop is generally not custodial because brief and temporary. The state action, government conduct analysis is inside the interrogation element. Explaining the questioning was done by a police or government agent, necessary to have a separate element to establish this. Miranda warnings are not required if the suspect is not aware the interrogator is a police officer. That comes from Illinois versus Perkins, which is an interesting case. I always forget the name of it. Where is Chicago? Anyway, trickery by the police. False promises made to accused may render confession involuntary. And factors: police conduct, defendant characteristics, time of statement. Those are the factors for circumstances. Okay, I didn't read volunteered statements yet. A defendant's volunteered statements are not protected by Miranda. A confession is involuntary only if the police coerce the defendant into making a confession. The totality of the circumstances determines whether the statement is voluntary. Once custodial interrogation begins, to secure the privilege against self-incrimination, anything the defendant says is inadmissible until the defendant is informed of Miranda rights and the defendant intelligently waives those rights. The exclusionary rule: evidence obtained in violation of the Fifth Amendment may not be introduced at trial to prove guilt. Fruit of the poisonous tree, inadmissible confession. Physical evidence. Under the fruit of poisonous tree doctrine, derivative physical evidence obtained from an inadmissible confession due to police failure to inform a suspect of Miranda rights is inadmissible. Public safety exception is a suspect is interrogated by police without Miranda warnings when the public safety is at risk. Miranda warnings removes the taint of a prior Miranda violation to admit a subsequent confession when the unwarranted questioning was unplanned or inadvertent. It gives Missouri versus Siebert. Siebert is the right case for that. I always forget the name. Evaluate if the police had the intent. Subjective test to circumvent Miranda warnings from Missouri versus Siebert. Then, privilege against compelled self-incrimination. Oh my God. Hot. Under the Fifth Amendment, a defendant may refuse to testify at a criminal trial. 9. Footnote 9. Fifth Amendment privilege does not protect against compulsion to perform physical acts or to submit physical evidence, such as a urine sample. a fingerprint, photo, measurements, writing, speaking, walking, gestures. The rest of the footnotes are from cases. A criminal defendant's right to testify on his or her own behalf is essential to due process and a fair trial, but does not extend to testifying falsely. That comes from Nix versus Whiteside. The burden of proof. The due process clause requires the prosecution to prove all the elements of a crime beyond a reasonable doubt, and the due process clause does not forbid the state from placing the burden of proving an affirmative defense on the defendant. So, the citation comes from Dixon versus United States. Examples of an affirmative defense, and the last part of that sentence was the defendant has to prove insanity, self-defense, entrapment, and duress. Burden of proof. So here's the jury instructions. Number 1. Deconstruct jury instructions into separate headings. There may be more than one instruction. One instruction may relate to crime elements. Another instruction may relate to affirmative defenses. That's cool. I haven't had to do that yet in essay. Felony murder. Substantial participation in a felony likely to result in death combined with reckless disregard for human life may justify the death penalty even absent taking a life or intent to kill. Because that's in the 8th Amendment. I just sort of skipped over the 5th Amendment. Other things, the 8th Amendment prohibits cruel and unusual punishment. A sentence grossly disproportionate to the crime constitutes cruel and unusual punishment. The death penalty may only be imposed under a statutory scheme that allows the fact finder discretion to determine mitigating circumstances, guidance, and defendant information. What's the guidance all about? Discretion, mitigating circumstances. I see here. Death penalty statute may not be vague. That's the answer to guidance. But the mitigating circumstances is the death sentence violates 8th and 14th Amendments if the sentencing judge refuses to admit or review or admit mitigating evidence. Information aggravating circumstances. In a defendant in a homicide case can't be sentenced to death unless a trial fact convicts the defendant of murder, and 2, finds at least one circumstance of the guilt or penalty phase. The aggravating circumstance must not apply to every defendant convicted of murder and be unconstitutionally vague. So let me finish 5th Amendment before going into 6th Amendment, right to counsel, ineffective counsel, standby counsel. So exculpatory evidence, to finish up the 5th Amendment, is the due process clause of the 5th Amendment applicable to states with the 14th Amendment requires a prosecutor to disclose to the defense and the court all known exculpatory evidence or information that tends to disprove guilt or mitigates an offense. Pretrial identification. The due process clause of the 5th Amendment applicable to states through the 14th Amendment prohibits a pretrial identification process that is unnecessarily suggestive and where there is a substantial likelihood of misidentification. 5th Amendment right to counsel. 5th Amendment right to counsel protects against the right to be free from compelled self-incrimination. And pretrial identification is not considered interrogation. There's footnotes here. 14, if a detainee invokes 5th Amendment right to counsel, all questioning must cease until the government provides an attorney or detainee initiates questioning. Police may not question even on an unrelated crime. That's not true. Prohibited against questioning. Last entire time detainee in custody, 14 days after detainee returns to normal life, can reinitiate questioning after 14 days without providing counsel. That's from Maryland versus Schatzer. 15, footnote 15, that is, ad rule and facts deal with pretrial identification. The accused does not have a right to counsel at photo identifications, U.S. versus Ash, 1973. So, right to counsel, this is the 6th Amendment right to counsel I'm going to go into. Oh my Lord. Apparently there was more. Well, maybe this is where it got out of order, actually. So, right to counsel, the Sixth Amendment. Applicable to states of the 14th Amendment provides right to counsel to the accused to in all felony cases and misdemeanor cases, imposing actual and suspended incarceration, and 3, at all critical stages of prosecution from the formal charge until sentencing, unless waived. Ineffective counsel. The right to counsel encompasses the right to be assisted with a reasonably competent attorney. An attorney is ineffective when representation falls below an objective reasonableness standard, and 2, deficient performance prejudices the defendant, resulting in an unreliable or fundamentally unfair outcome in the proceeding. Standby counsel, a criminal defendant who proceeds pro se, has no constitutional right to assistance of counsel. Standby counsel is at the judge's sole discretion. Waiver. A competent defendant has a right to refuse counsel and proceed pro se at trial unless the request is untimely or the defendant is unable or unwilling to abide by the procedural rules if the court finds the waiver knowing and intelligent. Exclusionary rule. Under the exclusionary rule, evidence obtained under Sixth Amendment violation of the Sixth Amendment right to counsel may not be introduced at trial to prove guilt. Confrontation clause under the Sixth Amendment applicable to the states of the 14th Amendment. The accused has the right to directly encounter and cross-examine adverse witnesses. Co-defendant confession. If 2 persons are tried together and a co-defendant confession implicates the defendant, the right of confrontation prohibits use of that confession, even where the confession interlocks with the defendant's own confession, which is admitted. The co-defendant confession may be admitted if all portions referring to the defendant are eliminated. The co-defendant takes the stand and subjects to cross-examination on the truth or falsity of the co-defendant's confession, and the co-defendant, I say and is not there. 3rd, the co-defendant confession is used to rebut the defendant's claim that the defendant's confession was obtained coercively. I think this is the last page, actually. A guilty plea waives constitutional claims. What did we get here? Guilty plea, okay. And must be voluntary and intelligent before a court accepts a guilty plea. The judge must personally advise the defendant. 1, guilty plea waives the right to trial. 2, right to plead not guilty. 3, critical elements of the charges. 4, maximum minimum sentence possible. Failure to advise the defendant of each point renders the plea involuntary. Guilty plea withdrawal. A defendant may withdraw a guilty plea if the defendant shows failure to meet the standards for taking a guilty plea. Sixth Amendment speedy trial. The speedy trial, applicable to the states of the 14th Amendment, guarantees a speedy trial post-accusation. Violation of the defendant's right to speedy trial depends on the totality of circumstances. The factors considered is the length of delay, the reason for the delay, the defendant's asserted right, prejudice to the defendant, or remedy for violating the right to speedy trial is dismissal of charges, prejudice. Sixth Amendment jury trial. The Sixth Amendment, applicable to the states through the 14th Amendment, provides the right to jury trials for serious offenses more than 6 months of imprisonment. Waiver. Unless the court or prosecutor compels the defendant to a jury trial when a fair trial is not denied, a defendant may waive a jury trial if the waiver is knowing and intelligent. There must be at least 6 jurors to satisfy the right to jury trial, unanimous. 6-person jurors must be unanimous, but no constitutional right to an ununanimous verdict if more than 6 jurors. Representative cross-section. The jury must be selected from a representative community cross-section. To establish absence of a representative community cross-section, 1, group excluded is distinctive in community. 2, group not fairly represented in jury pool. 3, underrepresented results from systemic exclusion of group in jury selection. peremptory challenges those disqualify potential jurors during the jury selection process without a need to show cause. The Equal Protection Clause of the 14th Amendment prohibits peremptory challenges based solely on race or gender. And jury trial, death penalty. Prospective jurors opposed to the death penalty may be removed for cause if their opposition prevents or substantially impairs performing their duties during the sentencing phase. That's going to be it for, I think that was all bar essays.com. Yes, essay attack template. And I didn't get to read my own outline. Not once. I printed it though. Pretrial motions, freestanding due process, incorporation, the 14th Amendment, Fifth Amendment, incorporation, like where are these cases incorporated, these acts, exclusionary rule, rule prohibiting the introduction of evidence obtained in violation of the Fourth Amendment, Weeks doctrine. Weeks' house was searched because neighbor told the cops where they could find a key to get into the property and obtain evidence to prepare a warrant. Holding in a federal prosecution, the Fourth Amendment barred the use of evidence secured through an illegal search and seizure. Wolf versus Colorado relied on the Weeks doctrine, holding in prosecution in a state court. I can't read this. Mapp versus Ohio, exclusionary rule does apply to the states. Leon, good faith exception to the exclusionary rule. Not going to announce rule required with two exceptions: threat of violence, destruction of evidence, called exigent circumstances. That's from Wilson versus Arkansas. What's this case? Hudson versus Michigan. Guns and drugs found, not going to announce for 3 to 5 seconds. Motion to suppress. Evidence found after search. Challenged this unreasonable wait time. Concept of exigent circumstances was further teased out. So the exclusionary rule does not apply to the not going to announce rule. Talking about societal costs, deterrent value, protected areas of an interest relating to privacy, what is unreasonable for purposes of the Fourth Amendment. That all is spelled out here. Before going into Alderman, I just don't have it in me to go through this. But I'm already on page 7. Try that some other time.